Welcome to Stolen, the world's greatest eminent domain podcast. Legally, the government has the power to take your property, but most people don't know what to do when it actually happens. If you don't respond correctly, you could walk away with far less than you're owed. And when that happens, in effect, the government steals your property. Our mission is simple: protect property owners, make sure they get the compensation they deserve. The government will steal your property, but only if you let them. Hi, I'm Chad Brown. Welcome to Stolen, the world's greatest eminent domain podcast. I am your co-host, and we are here again today talking about all things eminent domain related to property owners. I'm here with my co-host, Caleb Wheeler. Caleb, how's it going?
Hey, Chad. Thanks for having me.
Yeah, I mean, you have a choice. I mean,
I'm here.
All right, sorry. It's like every episode. It's like you don't have a choice. You work for me. You have to show up. All right, regardless. Okay, here we are. So one of the things that happens when you are involved in an eminent domain case is very quickly you realize that you don't have the vocabulary to navigate what's going on. I think one of the biggest hindrances to being able to get fair compensation and understand appraisals is really just you don't understand what in the world things are talking about. Unless you're like an appraiser or a realtor or an eminent domain lawyer. Or maybe a real property lawyer or someone else who has a lot of experience in real estate world, you just don't have the vocabulary necessary to even understand what are the different things they're talking about in these appraisals. So we're going to do a number of episodes, over time, but today is going to be one of those where we're basically going to introduce people to easements. Easements are very common in the eminent domain context. They frequently show up in various ways, both in property transactions, in property ownership, and then necessarily then in eminent domain cases. So we're going to talk, and we're actually going to do another episode on easements specifically related to eminent domain cases or condemnation actions. So that's actually going to be our next episode. So watch this one. If you want more, go see that one whenever it comes out. And but today we're going to talk about easements, and generally easements. And Caleb?
Yes, sir.
What's an easement?
An easement is basically this, Chad. And again, this is a great topic to get into because it not only affects folks who are being affected by eminent domain, but it also affects folks who are buying property for the first time, especially in subdivisions, or if they're close to any type of government type structure, i.e. a substation or whatever. So with that being said, an easement is simply this. It's a right to use somebody else's property for a specific purpose, but you don't actually own the property. You just have that right, that property right, to use that other person's property, but you don't pay taxes on it. You might have paid a fee one time to buy it, but that's about it.
Okay. So it's not ownership it's not an ownership of the property. It's an ownership of an interest in the property, but typically they're for a specific purpose, very limited. Sometimes, golly, we're going to get into this. I don't even want to get ahead. Sometimes they're not as limited as they probably should be. That's later. Sure. Hang tight. We're going to talk about that. Yes. Let's talk about some real basics with easements to help people understand.
Sure.
They're affirmative and negative easements.
That's right.
So what's that mean?
Affirmative easement is simply this. It's a right to enter or use the property. So it gives somebody the ability to come in and do something. Think of doing something on somebody else's property. And a negative easement is simply the converse of that, where it stops an owner from doing something on their property. So in that case, and that one kind of warrants a little bit of explanation because I saw this a lot when I was a real estate closing attorney. I saw it a lot in mountain development. So developments in Western North Carolina, where people would buy properties in a big subdivision, multi-million-dollar houses and such. They were not allowed to build sheds or barns that were a certain height because the fear was people on a mountain on a slope behind them would be their view of the mountains would be blocked. So that's where that would kind of come in. That's a negative.
So the negative easement.
That's right. That's
so basically a negative easement would be a restriction on what you can do on your property, but an affirmative easement would be something more like the utility company coming in, putting a power line in, which gives them an affirmative or a positive right to do something on your property that they normally wouldn't have a right to do because it's your property.
That's right. Do's and don'ts.
Okay. The way you remember that. All right. Very good. So if you're going to teach people vocabulary, we're going to have to get into a few words that are a little more technical.
Right.
But I think it's helpful because these issues run through eminent domain cases, and easements are such a big part of it. So let's talk about appurtenant versus gross easement. So what's appurtenant?
Oh man, you're giving me flashbacks to my law school days where I was scared to death of being cold called and stood up in front of a class for 50 minutes talking about one case. So going back to James McLaughlin's real estate property class and all this good stuff, and talking about these easements and these issues. Easements appurtenant are simply this, and I'll kind of give a definition to it, and then I'll kind of give an example. Okay. And the pertinent easement is simply this: it is a right to use somebody else's property that benefits another property. What do you mean, Cale? Okay, well, let's talk about it. There's two properties, A and B, and the property A is behind property B, and in front of property B is a road, a public road. And property A needs access to that road. So guess what they have? They have a driveway, a right-of-way that goes across property B's.
You know that like everyone in the world just calls that landlocked property.
That's called landlocked property.
Okay, well, let's just use phrases that people understand.
So landlocked property is simply this. That easement could be granted. It could be an express easement in the deed, or it could be something ordered by the court because it's easement by necessity. In other words, the landlocked property needs access to the road for emergencies, for access. It doesn't take a lot of imagination to see why that would be important.
Right. And so that's going to be tied to the land. What is a gross easement?
Gross
or an easement in gross, I think.
Easement in gross, that is basically the ability to enter on somebody's property and do something on that property, but it doesn't necessarily benefit another property. Okay, that's the difference between a pertinent easement and easement gross, is that one benefits another parcel, whereas the other doesn't benefit another parcel at all.
So, and we get some overlap, and we'll show some examples on how this overlaps. But so, for example, an affirmative easement where the utility company can come in and put a power line would also be an easement in gross, because it doesn't necessarily increase or somehow
benefit another property.
Benefit the property. I mean, it might, but it doesn't necessarily have to.
Right.
Okay, very good. So we've got positive and negative. We got affirmative and negative. We got appurtenant and gross.
Right.
How about use versus severed rights? What are those about?
So a use easement is simply this. It is simply the right to come on somebody's property and do something. It grants the right to use land for a particular purpose. Severed rights, and this all depends on the lens you're looking at it, because a severed rights easement is through the lens of the landowner, where the landowner retains ownership of the property but grants certain rights to another party.
Okay, so a use easement, if we go back to our landlocked property scenario, so you have a negative appurtenant. No, you have an affirmative appurtenant use easement.
That's right. That's right.
Okay. So they don't necessarily have to go together, but you see a lot of overlap and understanding. And I think the point for people to understand is that in the world of easements, there's sort of this give and take between why is the easement there? How does the easement operate? What does the easement restrict? What does the easement grant? Because when we get into the eminent domain space and when they start either impacting your easements or taking easements or expanding easements, it's a lot easier to understand why they can do what they can do, the government or the utility, if you sort of have a framework for it.
That's right.
Okay, very good. So severed rights easement, air rights, mineral rights, things of that nature.
Specifically, I think more of, in this case, we can think of severed rights easement is the owner retains ownership that gives certain rights to another party. When I think of that, what I really think about is not really in the mineral and the air rights context, although that could apply, but I really think of it as, let's say a dad owns a large tract of land. We see this a lot, especially here in rural North Carolina, where a father will own a large amount of land, or a mother, and they grant the front half of that property to a child to build their house, but they retain an access easement over the child's property. So that right of way, like we just talked about, the right of way access to the main road, they would retain that. So that would be a severed rights easement as well.
Okay.
Yes.
All right. So we're going to get in and look at how easements, we're going to talk some technical stuff here in a second, but talk about profits of Prendre.
Prophets of Prendre.
I didn't mispronounce that, by the way. That actually is the correct pronunciation.
Yes.
It's not misspelled. Tell us what that means.
Prophets of Prendre is simply a French phrase that means profits to be harvested. And that really refers to the old agricultural society in which we used to have, in that people used to retain a right in property to go on that land and harvest agricultural commodities off of that land. And that was something that was kind of, they held in perpetuity such that they could go on that property year after year and harvest, let's say, grass for hay. They could go on and pick apples, whatever it is. Prophets of Prendre were simply things that were tied to the land. So if corn was growing on that land, guess what? That corn is a result of the soil of that property, and they could go onto that land and take that or harvest it for their benefit. But they didn't own the land; they just had the right to harvest on the land.
Okay, so it's a very specific.
Yes,
it's like a very specific type of. Is it closer to a severed right or a use right, or is it just a completely different thing?
I would say it's closer to a use right, but I think it is a completely different thing, because use rights really are it's a more overarching principle, whereas this is a more specific principle. And one thing to be thinking about with Prophets of Prendre is a lot of times we see it in the United States with gas rights, oil rights. People in Texas and Oklahoma are more affected by this than we are here in North Carolina. But there's also mineral rights to be able to go pull minerals out of the ground. That's a Prophet of Prendre. And then you also have people get confused with the water. And so water, if it's a creek flowing through your property, and if it's a navigable creek and all that, then that is a flowing commodity that cannot be harvested. But if you were to, this will help define it a little bit better too. But if you were to take that water and put it in cisterns and hold it, and then you come and get that water out of those cisterns, that would be a Prophet of Prendre, because it's held rather than not free flowing.
Oh,
yes. So that it has to have the ability to have ownership. You can't take ownership.
So if there was like a giant underground pool under your property,
it's
like if you lived on like top of a cave complex, right, way deep underneath there was a big pool of water. Like taking that, the right to take that, the easement would be a Prophet
of Prendre. Yes, that would be Prophet of Prendre. Yes, sir. Yes, sir. And that's important because one of the things one of the reasons this is important is because simply this: some people have signed their mineral rights away in the chain of title, and homeowners, they're going to buy a property, need to be aware of that.
Right.
So because obviously John Locke says we own from the center of the earth to the heavens and the sky when you buy property. And so with that being said, you need to know if you have the right to your minerals and stuff as well, right, if you buy a property. So
and I guess in a very specific set of cases, if you had these rights and your property was taken for purposes of eminent domain or someone else, or I guess maybe the more likely scenario would be you hold those rights on someone else's property,
right, and
that other property is impacted by eminent domain, then you're going to have rights. See, it's not just because the property is being affected when you have eminent domain. What you're looking at is there's a taking of a property right, not necessarily a fee simple taking just of the property. They take rights as well. And one of those rights are frequently tied up in some context in easements.
That's absolutely right. If that's happening to you, you definitely have a right to be added to that lawsuit for that eminent domain suit. But the problem could arise if the DOT or any government entity that is performing the act of eminent domain, if they don't do a proper title search and they discover that you have mineral rights on that property, and they don't have they don't ever not do that, right? No. But that would give you grounds to say, hey, I should be added to this suit so I can be compensated.
Right. So very good. So let's jump back out of eminent domain back into the easement world.
Sure.
Just really specifically. So how are easements? How can you acquire or how can you grant an easement? Like just practically, how do they come about?
We've alluded to this already a little bit, but the example I gave about the parent to the child, so there can be gifts. You can gift an easement. You can purchase an easement. You can gain an easement by prescription, which
let's just stop with that. So the first ones are, they would typically fall into the category of voluntary. That is voluntary grants or voluntary easements. That is, there's nothing there's no taking, there's no adverse possession, which we'll talk about in a second. It's people entering into fair and level transactions, exchange the rights in some capacity.
That's exactly right.
Okay, perfect.
Bargain for exchange, there's a quid pro quo, and then because of that, we have a voluntary exchange.
Okay. Rights. But what about prescription? Because that's a different. What's that?
Yeah. So prescriptive easements are simply this. It's a form of adverse possession.
Okay.
Whereas
nobody knows what
adverse possession is simply this.
Stop. Can you tell them what adverse possession?
Adverse possession is simply this. It is simply your rights to your property being taken away from you. Why? Is because somebody else has been using it for a prescribed amount of time, and for that amount of time, usually it's been open, hostile, and adverse to your interest. And it's been continuous. So it's been without any type of break in the chain. It's been done continuously. In North Carolina, for 20 years is the amount of time that requires.
So in adverse possession, basically what you have is, I don't know, this is probably, I don't know, some real estate lawyer is going to say this is incorrect, but it's kind of like a squatter situation. So someone squats on your property on the back corner of your property. They're there. They're they're not supposed to be there. They're not supposed to be there. They stay there. At some point, they get an interest, and that happens with easements and prescription. Is that correct?
That's exactly.
As a prescription easement that's happening in the easement context.
Okay. And the classic example of that is the guy who walked across somebody's property for 15 years to access the lake.
Okay.
And he did it like the guy saw him for 15 years walk across that property. And all of a sudden he says, I'm going to put a gate up and I'm not going to let him do it anymore. Well, it was too late by that point. He had done it so long that he was able to countersue and get that prescriptive easement.
Okay. So you got voluntary easements, you got prescriptive easements. So what happens when the government creates an easement on your property through a taking?
Yeah, that's an eminent domain easement. I mean, that is a classic example of a involuntary easement that is taken from you by the government. And so the eminent domain is another classic example of how an easement can be taken. That will be done through court order,
right?
Typically through court order. Sometimes they'll try to settle before a lawsuit is filed. However, with that being said, even if that's done, it's still involuntary because you didn't ask for it.
Right.
You just have to settle.
I think it's fair and so when you're looking at the easements in the context of eminent domain or condemnation actions, what you see is typically either there's a creation of an easement that wasn't there before. Mm-hmm. So let's say the utility company comes in and they're going to run, I don't know, I just use Colonial Pipeline or one of these pipeline, Mountain Valley, one of these pipeline companies. And they're going to come in and they're going to put their pipeline across your property. There wasn't an easement before, but now there is. So they created it. The easement is new, so to speak.
That's right.
But sometimes, for example, like in a road widening, what they'll do is because they pushed the road over, they already had an easement. They already had there's already, say, a public utility easement on that property, but now it's being expanded. So in eminent domain, you have either the sort of the creation of new easements or you have expansion of existing easements.
Right.
Okay. What about necessity?
Easement by necessity is simply an easement it's created because without that easement, the property owner would have no access to that property. He would be essentially landlocked and unable to access that property. And the courts have ruled in multiple instances that people have a right to access public roadworks. So if there's no other reasonable way to, again, the whole thing, Chad, is reasonable. So if there's no other reasonable way to access your property, then the court will typically allow for an easement by necessity. And the classic example of that is early 1900s, case out of Ohio. There was an older farmer who was essentially landlocked by this young lawyer who had the
that'd be you. I'm not even.
Yeah, I know, right? But in heart. Yeah. So he was wearing tennis shoes to work. So anyways, but so this young lawyer bought a piece of property from the farmer in Ohio, and he blocked his access to the public highway. And the farmer asked him for an easement across his property. The young lawyer said no because it would affect his property's value. But the farmer didn't quit there. He went after him, and after some legal work and writing a few letters, a judge eventually did grant the farmer an easement across this young lawyer's land to access the road. And that easement stood over many years, even when that young lawyer sold that property, it stood because, as we mentioned earlier, these types of easements, these are easements that run with the land.
So just to circle back, so now we have an appurtenant use easement granted by necessity.
That's right.
Fair enough. Okay. We were going to talk about the legal creation, but that's really boring. Nobody cares how the documents are created. If you need an easement, let a lawyer do it. Don't draft it on your own napkin.
Please
It's a good way to have a really bad outcome for your grandkids 39 years from now. But let's talk about easements in eminent domain. 10,000 foot view, do a flyover.
Sure.
Four, wait, there could be more. We typically see 4 types of easements. Let's just hit them. Let's just hit those. And then we'll leave the details to the specific eminent domain easement podcast. So let's talk about temporary construction easements. What's that?
Oh yeah, so temporary construction easements, permanent utility easements, drainage easements, and slope easements. Right now, temporary construction easements are simply this: the government or its contractors, they're going to need a specific parcel of your property, a portion of your property, so that they can perform the act of constructing whatever the project is. It'd be road widening, installing a gas or water line, whatever it is. They're going to need a construction easement that will be temporary in nature to finish that work. And so one of the hallmarks of a temporary construction easement is this: they're highly destructive and they're temporary.
Right.
Those are 2 hallmarks.
So you're driving down the road and they're widening. They're widening the road, and you look over, and like on some guy's property, there's a gravel parking lot with like 9 pieces of equipment there. It's probably sitting on a temporary construction easement.
It could be, yes.
I mean, it's very likely.
Very likely
that's what's going on. Okay.
Yes.
Public utility easement.
Public utility easements is an easement that goes along and runs with the land. Okay, it runs with the land, so it lasts, and it's not temporary at all.
Yeah, it's not public; it's permanent. I'm just not even using the right words.
It's permanent. Yeah,
permanent.
Yeah,
it could be public, it could be private, but it's permanent.
Permanent. Yeah, it's permanent. That's
going to make the phrase right. It's permanent utility easement. My bad. It's completely on me.
So, a permanent utility easement is simply this: it is where the government takes property for the purpose of a specific task or service, and usually that's going to be power line, water line, gas line, the cable lines for internet.
Okay.
So those kind of things. So those kinds of easements are permanent. That's one of the hallmarks of that. And historically, here recently, we've been seeing the language being drafted very, very, very widely. When I say that, it's pretty all-encompassing, which is an issue, but we'll get to that later. But these easements typically are in perpetuity, and they run with the land.
And so the average person would understand most common a permanent utility easement is being used for, gas power.
Yeah, absolutely.
And the utility easement, while taken, say, by the DOT, is typically going to be used by, it may or may not be used by the state. It may be used by Duke Energy or Energy United or pipeline company, whoever it is.
That's exactly what happens.
Right. So what about
drainage easements?
Drainage easements.
Yeah, drainage easements are when the government takes it's similar to a permanent utility easement that it is permanent typically. So drainage easements can be temporary or permanent. Okay. They can be temporary or permanent, and they're exactly what you think they are. They are for the government to drain water onto your property while they're constructing the new road or when they're constructing a new substation, whatever it is. As long as they have that easement, they can direct water into that area.
So they could run water into your property. They could run water through your property. They could do it temporarily. They could do it permanently.
They can pull it in your property. And the issues that come with that obviously are going to be,
we'll hit those.
The damages. Yeah.
We'll hit those later. Figure that out. And finally, slope easements. I don't spend a lot of time on that.
Slope easements are if they're having to affect the grade of the road, in other words, really pick the road up off of sea level. There's going to obviously be a slope there that the state has to maintain. They have to be able to access that to maintain that slope by ground cover and whatnot. And because of that, you're not going to be able to use that property anymore for most purposes because it's really hard to use a slope for anything.
Right.
So, but you still have access to the property. You still own it. You just can't really use it for much.
Yeah.
So slope easements are unique, but that's what a slope easement is.
Cool. All right. We're out of time. time flies and you're having fun talking about easements.
Right.
It's important though. It's not just legal jargon, gobbledygook that we're up here spinning. Like if you're in an eminent domain action, you're going to get an appraisal, and it's almost always going to have easement. It's going to have some language about easements. It's going to have compensation tied to the easements. It's almost unavoidable unless it's just a complete taking, full taking. In almost any partial taking context, you're very common going to have an easement issue. So, if you're a property owner, you need to understand what it is you actually own. And when you're in eminent domain action, you need to understand exactly what's being taken or what's being restricted and how that's going to impact you down the road. So, Caleb.
Yes, sir.
Easements, thank you.
Yes, sir. Thank you.
We will be back next time. We're going to dive deep into easements in the eminent domain context. But for now, subscribe. Thank you for watching. Don't let the government take your property without making sure you do what you need to do to get the money that they owe you. Until next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.